So welcome back to JC Law Podcast.
So let's go back to the process of what happens once you receive that knock on the front door. So you get charged after that. What happens after you're charged?
Well, generally, it depends upon what state, and it depends upon what, if it's a federal level or state level. Most of the time, the government or state will not charge you immediately. Mm-hmm. And that was a practical experience scenario because they wanted to take the computer and take it to a lab and look at it. Now they don't have to do a whole lot of that. They've got a lot of programs that they can look pretty quickly and make determinations if CP was on there, it's on there, if it's hit in the cache, wherever the heck it is. Mm-hmm. So once they go through the experience of being accosted, I'll say, in the morning, they take their electronics, and sometimes things don't happen for weeks. Sometimes for months, sometimes for a year. It used to be for a year. Now I would say I've seen it happen pretty quickly. I'm seeing more and more arrests initially, but still not that many. So once a person is charged with any type of pornography from a standpoint, and we're talking about generally on a state level now, if it's distribution, that's one thing. If it's basically creating CP, that's something totally different. If it's simple possession, that's something different unto itself. And of course, it depends upon how many video and how many items they have in their possession. On a federal level, the guidelines, the federal sentencing guidelines, look at that not as an individual image. They will give points, so to speak, for each video and each image. So there's a calculation. So depending upon how many possessed images or created images, it just depends. Generally, about 65% of people, 70% will get out of jail pending trial. Again, it depends upon if you're in a city, if you're in a rural county. But the thing about it is that most judges in smaller towns will not, they can't get over it. They just look at it as a heinous act and they're not really looking at it in detail. Mm-hmm. So you can get out on bail. You absolutely have to have an experienced lawyer with you at that stage of the game. Right. If you don't, you're shooting yourself in the head.
Right. If you don't have somebody that understands, like you said, the issues of what you're going through and how to advocate for you, even as early as the bail hearing, or even before that, like we talked about with Mark, with the investigation, with the detectives, then it's a lot more difficult to get this thing resolved.
Yeah, I really believe that the investigation can make or break someone in these scenarios, because as soon as they come after you, you've got to have a lawyer who knows what they're doing. You can't go to a general practitioner and doctor to do heart surgery. You just can't. Right. You have to go to someone who has had the experience of dealing with these cases over and over and over again. Doesn't mean you can't find someone that hasn't. It's not good. It's just that you have to be brave enough to ask. Most people are so scared they're just going to follow what anybody tells them. Mm-hmm. No, find the right lawyer, find the right law firm, look at their experience, look at what they've done in the past, and choose them, and go from there.
So you go to the bail hearing, and then what happens after the bail hearing? Is that when the formal merits happens, or is it just really it just depends?
It depends. I mean, with most people think bail hearings are 30 seconds long or 2 minutes long. On a case like this, I've had bail hearings that last half a day because I'm looking to introduce certain evidence to show a judge or convince a judge that this person can be released and it's not going to be harm to society. And in fact, they will show up to the case, et cetera, et cetera. So once the bail review is over with, you then have the task of trying to prepare and really seeing what the state or the government has. Mm-hmm. I would say this, and my state's attorney friends out there, please don't take offense to this because some of you are very good, but I would say that the majority of prosecutors across this country that handle these things really have not had that much experience in actually trying these CP cases. Mm-hmm. They rely on the apparatus around them. They rely on the detectives. They rely on the agents to educate them.
Well, I think it's about 85 to 95% of cases right now are being pled out within the court system. So I would assume that pornography is no different. or child pornography is no different, your sexual offenses are no different, where about 85 to 90% of those cases do get pled out.
Well, I guess my reputation and what I've done on these things is my first intent is not to plead on that. That's my
Yeah,
first intent.
it's nothing, no commentary on who you are as an attorney or your representation. I'm thinking generally, and the reason why they haven't really tried these cases is probably because that's the normal process for most other attorneys.
Yeah, most lawyers, I shouldn't say most, some lawyers who look at the information provided to them in the discovery package, Giglio or whatever, are looking at that and they think that it's an open and shut scenario for the government or for the state.
Mm-hmm.
It's not. I would advise any lawyer who really is looking to get into this to do it. First off, you have to read all the statutory and all the case law revolving around this. But second, you have to find some good experts.
Mm-hmm.
Because you have to understand what's going on there. Okay, because at any given time, there could be a problem with possession, there could be a problem with where this information came in, and it's not that easy for the prosecuting team to really always win. It just isn't. So you have to have good experts, and you have to have experts that can look at phones, look at electronic device, and advise you about where it is, how it got there, et cetera, et cetera. Listen, a very key component of any prosecution, in my book, I don't care what level it is the searches. You know, if the government can show that someone was actually searching for very specific CP, then that's a big lift, right?
That's something you've always been interested in is the Fourth Amendment of the Warren Court back in the 60s and 70s. You've always talked to me about that. I know you talked to Mark and a lot of other attorneys about that here. Why do you find the Fourth Amendment and that issue so interesting?
Well, I think that, you know, even with CP cases and or sex offense cases, every case has to start with an analysis of due process in the Fourth Amendment. Has to start with that. I live and die with that. And, you know, there's many ways and many times that can be used in order to try to, you know, throw a right hook or a left jab to the state or the government to push them back a little bit. So the Fourth Amendment, as far as that, is very, very interesting. I'll give you an example. So everybody thinks CP is pretty cut and dry, you know, in society. If you read an article, they think, well, this person possessed it, you're guilty. And it's unbelievable the connotations that come with that. If you're, God forbid, if you're accused of a sex offense or CP, you are tainted. You're tainted, and it's a bad, bad thing. It really is. The reality is that many times it didn't happen the way it said it happened. They said it happened, especially with sex offense cases. Now, what happens is the federal government will give grants to a lot of police departments and sheriff departments around the country. And all of a sudden, this money that this county government is getting, all of a sudden they turn into these major sex offense and or CP units because they now have the money. And they help, and the federal government helps with them. So over the years, there's different programs that the state and the feds have used to try to capture people. The problem is that, for example, when they're out searching on the BitTorrent programs, or even in some of the social media programs, they have developed, meaning the prosecution and the government, okay? There's a federal unit that basically called themselves Unit for the Protection of Missing and Exploited Children across the country, that has really categorized millions and millions of CP and pornography cases. So a detective will have access to that through a program. So when they're looking for CP on another individual's computer, that program will identify and track it. But here's the problem. Many times that program is not actually downloaded from the defendant's computer or electronic device. So there's all kinds of issues as far as how that program identifies that, because they don't actually have the device. It's almost like a detective going into a den of inequity and finding drugs and saying, oh, I see that drug, but never grabbing the drug and coming out and testifying that I saw it, but they never produced it.
That's an issue. It's a
Many
big
ways,
issue.
yeah.
And is the original third party, are they a third party or are they a state actor? How do they get around that, the state actor provision of the Fourth Amendment? I mean, do they act on behalf of the state, or is it just some separate entity that does this for charity?
Well, it depends what you're talking about. I mean, if you're talking about the social media apparatus, what's happened is most of the social media apparatuses have an agreement with the government. That and many vendors too, that they will have people that watch, and if they notice anything unusual, they will notify the Department for Missing and Exploited Children or the local police department.
Gotcha. So it is connected to the state in some way.
So some way, yeah. So, but so it's not necessarily an origination argument as far as how they got to that person. It could be an argument as far as identifying and actually going after the crime itself.
That makes more sense. I think I was getting at, like you said, the origination of, obviously, the Fourth Amendment analysis can only occur if it's a state actor violating the Fourth Amendment. If it's a third party giving that evidence, then it's not a Fourth Amendment violation. So that's kind of where I was getting at with that, which makes sense.
And so here's a little tip for a lot of lawyers who are interested in this area of the law, because this is growing. This is not waning. This is a feature. This is something that's going to continue to grow. Here's a little tip. If I was listening to me, I would listen to this very hard. If you want to understand how to do this, understand how the system works as far as the computers are concerned, and understand how a detective thinks and how they try to prosecute. And also understand this, that most state's attorneys or federal prosecutors do not want to try these cases. They're messy, they're unpredictable. You know, for the most part, there's some that are like pretty open and closed. I mean, you get that. But many of them are not very predictable. And there's a lot of evidentiary issues to go into these things.
Would you say it'd be more predictable in the state level versus the federal level?
No, not necessarily. I would say that probably on the federal level, most of the district offices have designated federal prosecutors who know how to try these cases. On a state level, most of the prosecutors who try these cases may be like in a sex offense unit, and they've maybe pled out 10 of these cases, but they never actually tried one of these things.
Right.
You know, so they're a little hesitant, so that gives you some ammunition to try to work something out. In some of these jurisdictions, I can tell you right away exactly what's going to happen, what the state or the government's going to offer, and where we're going to end up.
What's the benefit of doing this so much? Like I said, you built your career off of some of these cases, you really have. So you're one of the experts in this field. Not that there are lawyer experts, there are no technical experts, but if anybody would be one, you would be one. The amount of cases you've handled has been tremendous throughout your career.
I just find that, and it's interesting because the court system is really starting to catch up to some of these things. It is imperative about how a lawyer approaches these cases. You can't go in there with your tail tucked between your legs. You've got to go in there, kind of like Brian Belichick said it for the 2000 Ravens when he went to the Super Bowl. He said, you got to go into the bear's cave with the hatchet in one hand and a knife in the other hand, like a wild banshee. I'm being a little silly here, but I'm saying you can't be afraid of a good fight. You have to be able to take it to them, and you have to be willing to try the case. I'm not saying anything that any experienced attorney in any area doesn't know.
True.
You know?
All right, well, thank you for joining us today. I appreciate it. This has been an interesting insight on the mind of people who go through this, both the victim's mind, the potential perpetrator's mind, the lawyer's mind, society's mind. It's been a good time. So I appreciate you having this conversation.
Enjoyed it very much.
Thanks.